Hi, I'm Beck and I'm a property investor.
And I'm Daria. I own my own home and I'm curious about investing.
We're the hosts of Investors in the Wild.
We've heard it all before. Build your wealth, get expert advice, learn about high yield, high growth investments, blah, blah, blah.
That's just not us. We're real mates with real talk about real estate. No ego, no financial advice.
It's all about wins you can use right now.
Let's get into it.
Hello, welcome back. If you haven't listened to part one with Tessa yet, go back and do that now because it sets a really good foundation before today's episode, which is part two. We're back with Tessa, family law partner, and honestly one of the most insightful humans we've ever heard from. And in this episode, things get really specific. We're covering Patrick, a guy who took a quick exit after a breakup and later regretted every single bit of it. We're getting into stamp duty exemptions you probably didn't know existed, and Tessa is dropping something that affects so many Australian property buyers right now, whether your mum and dad's money should be a gift or a loan and why that matters enormously if things go sideways. Welcome to part two. Let's get into it.
Your listeners will probably be interested in buying property in the Sydney market or Australia generally. We're often looking at being gifted money by parents or loaned money. Yes. So many people, particularly with the transfer of wealth through the generations at the moment, there's a big transfer of wealth we see coming down from parents and grandparents to the younger generations purchasing property. So I'm often quizzed on, should it be a gift or is a loan better from a property settlement perspective? So let's just imagine two people are in a relationship and I'm going to be given some money by my parents to help me buy a property. Should it be by way of a gift or a loan? If you meet the threshold of a de facto relationship, then the family court can make orders dividing and giving a share to any partner that's in a de facto relationship based on a number of factors. So let's look at it from the beginning. The first question is, are these two people in a de facto relationship? If they're not in a de facto relationship or they're not married, the family court cannot actually divide their property. So whether or not someone's in a de facto relationship is often one of the first questions I'm asked, or if I'm talking at an event, people say, what is a de facto relationship? And it's not black and white. There's a number of factors that one would look at in saying, what is a de facto relationship? And they're set out under the Family Law Act. But essentially the sort of things that we would look at are, have the people been together for 2 or more years? But they don't have to have been. If they have a child or they've registered their relationship, partner X comes from overseas and they've decided to get that person through, they'll write on a document that they're in a de facto relationship. So there's a number of factors we look at as to whether or not someone's de facto. And essentially we're looking at, are these two people in what we call a genuine domestic relationship? And that also looks at things like the public aspects of their relationship, the sexual relations, what they say to people about their relationship, whether they own properties together, what they do together. If they didn't, they were living together, but they were just friends and they were dating other people and it was all a bit complicated, then it may well be that the family court says, you're not actually de facto, so we're not going to do anything. So they've opened the first door, as I like to say. They've met the threshold where the family court can make orders. That then means that lawyers can get involved and say, look, there is property here, and you don't want the court to do something, so why don't you try and resolve something outside court? Whereas if there was no de facto relationship, I would just be saying, go away. You can't take anything anyway because you've got no grounding or standing in court. So that's where that piece matters. So we're through the de facto threshold door, so to speak. The next thing we look at is, well, there is some property. Should it be divided or how should it be divided? And very generally speaking, the way that we look at that is through what we call a 5-step process in family law. And that is born out of the Family Law Act. But essentially we look at, and the court would look at it, lawyers would look at it this way, mediators, everyone who practices in this space. There's two people, they have property. The first step is, does there need to be any sort of property adjustment or property settlement at all? And in some cases, there doesn't. People might have been together for a very short period. No contributions were made by the other person. They should just go on their merry ways and keep what they have. But often there is a property adjustment. That's the first step. Do we even need to adjust the property? We would then be looking at what assets and liabilities do these people have. That includes properties, superannuation, shares, cryptocurrency, bank accounts, trusts, corporations, you name it, it's all in what we call the asset pool. And I like to talk to clients and use the concept of we've got this big bucket. You need to throw all the assets in there and all the liabilities on both sides, no matter how they're held. So even if you own something with somebody else, with a friend, you own it jointly, it doesn't matter. It all goes in for consideration. Essentially, that bucket should contain and must contain everything. You need to disclose everything you have, even if you were de facto, and even if that person wasn't living in or made no contributions to those other assets. But before we all get really worried about this point, the next step is actually to look at the contributions that we've made to those assets. So think of this more as family law as a show your cards jurisdiction. You're sitting in front of each other. Here you go. This is everything I have. You need to disclose it all. And the Family Law Act actually provides you must disclose. It's a breach if you don't of the Family Law Act. But that doesn't mean that person's entitled to everything you have. It's more so that we can consider it all. So we need to look at each person's financial circumstances in their full picture rather than just in terms of what they lived in or what they might have done together. The next step is we say, this is everything that's in the pool we need to disclose. And then we are required to look at the contributions made to the assets and to the asset pool. And we look at a variety of different contributions. We look at financial contributions. We also look at non-financial contributions. So sometimes in these types of scenarios, the person who didn't bring any assets might have been at home every day, cleaning the house, helping with renovations, helping to refit out the property, constantly decorating, etc. They've made a large amount of non-financial contributions. And we also look at homemaking and parenting contributions. So if there was a child, the contribution to the parenting share as well. We look at contributions when they started the relationship. Think of it a bit like a seesaw. The court would then say, we need to look at the future needs of both these parties. So this comes to what we call the fourth step. What are the future needs of each party? And that's looking at things like the health of the parties, their income earning capacity, their income earning ability, whether there's any children, essentially looking forward. Now, if she was earning $2 million a year and he was earning nothing, or he didn't have a job, or he was injured or something, then that's going to be taken into account as well. And usually they would
back the truck. I'm getting palpitations. What did this happen to Denise Richards, right? But so hang on. So say she's earning $2 million in that 4 years. Are you saying that he could have rights to her future earnings because he has no job?
Okay, so that's a different question. I'm not saying that in this scenario. I'm saying, say we've got an asset pool. Let's just imagine their asset pool was $1 million, an apartment worth $1 million. Looking at what share of the asset pool, the court also requires you to look at what are the future needs of the parties. Now, you're asking about another concept which is relevant too, which is spouse maintenance, which is, should there be an ongoing payment?
Oh my God. So hang on, there's two elements that could be paid out in addition to, one is spousal maintenance and one is the other.
No, so the future needs sit within the property consideration.
Okay.
So remember, we've got our property bucket. All the assets are in here. We have to look at what are future needs and were any of those future needs increase as a result of the relationship. So if the female bore children and then was not able to work, we'd say, or the dad might be the one who is staying home with the kids. He's going to need to get more of the asset pool. But it's also relevant if he's earning far less than her. But that's what we're required to look at in terms of looking at the future needs. Let's assume they're both earning a similar wage. No one's got a health issue. We can both work happily and our income earning capacity is good. Then we wouldn't change anything. And he'll get a share of the asset pool based on those sort of contributions factors. But it's important to know that the future needs factors can be really relevant in some cases, particularly if someone's unwell or there are young children.
So imagine if he gets unwell throughout the course of the relationship, then, really quickly, then what happens? If he's diagnosed with a terrible condition, and then what happens?
Then it's taken into account, and he will get a higher percentage if he's unable to earn an income and she's able to earn a higher income. So many people, particularly with the transfer of wealth through the generations at the moment, there's a big transfer of wealth we see coming down from parents and grandparents to the younger generations purchasing property. So I'm often quizzed on, should it be a gift or is a loan better from a property settlement perspective? So let's just imagine two people are in a relationship and I'm going to be given some money by my parents to help me buy a property. Should it be by way of a gift or a loan? Now, I'll just talk quickly about the ramifications of each now that we've talked about how a property settlement occurs. If I'm given a gift, that is seen as a contribution I've made. So when we talked about those financial contributions, a gift that I bring in terms of a financial gift is a contribution I've made. Now, I'll just talk quickly about the ramifications of each now that we've talked about how a property settlement occurs. If I'm given a gift, that is seen as a contribution I've made. So when we talked about those financial contributions, a gift that I bring in terms of a financial gift is a contribution I've made. But like we talked about, I'm not going to get it back dollar for dollar. So I get a $50,000 gift, I put it into a property, my partner and I buy that property together, we then separate and my dad says, I want my $50,000 back. He's gifted that. It's blurred into the relationship. It goes into that sort of gut feel contributions factor. It's on my side of the seesaw, but it doesn't come back as 50,000, nor does it come back as, say, 100,000 if the property doubled in value. It's not a mathematical exercise. Compare that to if he loaned me the money. So he gives me a loan for $50,000 and it's drawn up properly. I have to emphasize that, properly via lawyers. And it's a commercial loan with the right interest terms, et cetera, then provided all of that is taken into account, the court will recognize that loan and say, you owe this money to your dad before you have a property settlement. So it comes back out of the asset pool and goes back to the person who loaned it to me.
Oh, so the gift won't go back, any portion of that won't go back to your parents?
Because it was gifted, no. Wow. But it will come back. It'll be taken into account in my share. So I'll take out whatever percentage I'm entitled to of the asset pool and I'll get some credit for the gift, but not dollar for dollar, whereas a loan will come out dollar for dollar. So people are often asking, if I'm having money injected from family members, what are the different ways that can happen and what are the ramifications? And really important for people investing in property because that's such a common scenario. And the number of times I've seen people argue over whether a loan is legit is just, it always happens. And the answer to that, if you do the loan method, is just to make sure it's a properly legally drafted loan, because otherwise it can be challenged if it's drawn up between two people and signed and it wasn't really a commercial loan document.
I'm going to pause us here because what Tessa just said about gifts versus loans, that is the kind of thing that most people find out the hard way years too late. I actually know someone who's going through this at the moment, and if they'd known about this nuance, things would be very different right now. If your parents have ever helped you buy a property or that conversation is coming up in your family, please share this episode with them. Share this episode with a friend, a sibling, share it with whoever needs to hear it. This is exactly the kind of stuff we started this podcast to talk about. The things that nobody tells you until it's too late. All right, let's get back into it. All right, case study Patrick. Patrick has been with his girlfriend for 5 years and they decide to buy an apartment together. It's the first place they're both buying. They're really excited about it. Unfortunately, about a year after buying the apartment, they break up. Patrick decides that he doesn't want anything to do with the apartment anymore. He doesn't want anything to do with the relationship. He's really upset that the relationship has ended. And so he says, I just buy me out my half and I'll just go on my way. I just want this done. A few years later, that apartment ends up growing significantly in value, and Patrick regrets not asking for more to capture the kind of unrealized gains that ended up happening. Any thoughts on that one?
Yeah, so that's a tricky one. I'm going to give some, again, timing and scenario thoughts, because if I was acting for Patrick, I would initially be looking, and obviously I'm not a psychologist, but I think this is what is important for a good family lawyer to do, looking a little bit and challenging Patrick on his state of mind. So he's really grieving. He's so upset about this relationship. Is he having a knee-jerk reaction in saying, I'll just take my 50%. I'm not going to look at the future potential gain of the property. I just want to get out of here. And he's trying to solve this really quickly, it sounds like, and he's trying to extract himself. So if I'm representing the person who's really affected by this breakdown, I'll often ask them to put the brakes on. So we'll have a discussion, we'll talk about what his entitlement might be, and maybe it is that it's 50% at that point in time. But we'll be saying, get some financial advice as well. Let's do some projecting of your future. Let's consider your property might be in a really hot area of Sydney. Let's look at, does the financial advice project that this property is going to go up in the future? And do you want to capture anything in terms of the settlement to take that into account? So I think that's an important piece that maybe some family lawyers don't look at. That's certainly part of the package in terms of when I say, well, what do we need to look at the start? It's where that person is in their frame of mind. Now, Patrick obviously went ahead and just had a settlement. I'm assuming that he had a legally signed settlement.
I don't think it was a legal agreement.
Okay. So there's a couple of things to say about that, which is really important for Patrick. So when you reach a settlement, ideally it's done through the court formally. There's a couple of benefits. If Patrick was being bought out and they did own the property together, then the title to the property was going to be transferred to his ex-partner, and stamp duty often flows. When you transfer your title to someone else, they pay a share of stamp duty. You can get an exemption from paying any stamp duty, provided that you've formally transferred the property pursuant to a marriage breakdown that's been documented or a de facto relationship breakdown. So just to say that in a bit more plain English, if two people separate and they want to transfer property from one spouse to the other, provided you sign the proper paperwork and it's stamped by the court, or it's in a financial agreement, and that sounds a little bit complicated, but just to put it really plainly, you can do a financial agreement at the end of your relationship as the formal paperwork, or you can lodge the agreement through the court. So there's just two ways you can lodge that final agreement. But if you've done it properly, you can lodge that document with the duties agency and get an exemption from stamp duty. So that's a really important point, because that type of simple agreement doesn't cost much for a lawyer to draft up, but you get the stamp duty exemption, which is often more than the legal fees anyway. And secondly, it gives protection. So if you've formally had a property settlement and it was legally stamped, in Patrick's case, he can't really come back on it because he's had legal advice. They've probably both had legal advice. It's been formally done, and he's had the stamp duty exemption as an ancillary benefit of that. If they just had an agreement and they just said, yeah, we're going to agree this, it might even be a text message, transfer the property, they didn't get the stamp duty exemption, Patrick can actually go back, provided that certain timeframes were still in play. If they weren't married, then they needed to be separated for less than 2 years to be able to go back and say, well, I want to undo that settlement. If they were married, then a 12-month time period applies, because they actually didn't formalize their settlement. So there's a period of time after the breakdown where he can say, sure, we had a settlement, but it wasn't formal. So I'm coming back to my lawyers now and I've decided that I don't like what happened and I think I'm actually entitled to more because the property's gone up in value, for instance.
If Patrick officially took the steps to put that property in his ex's name, does that classify as the formal agreement? Or, because I was thinking a separate formal agreement is what classifies as the
separate formal agreement.
So technically Patrick, because they don't have that formal legal agreement in place, could go back.
Yeah, depending on the time frame. So we would look at when did they formally separate and what passage of time has passed since separation. And depending on whether he's within the window where they can still go to the court and say, look, we didn't separate that long ago, we didn't have a formal property settlement, so I'd like to come back and have one, then they can go. Patrick could say, I want to come back to the court and open that up, or go to a lawyer, get some advice. The lawyer might say, look, you've still got a chance to open that, but it all depends on the timing and when they separated.
Okay.
Does that mean after a breakup like that, are you on standby for 2 years waiting to see if anyone makes a move?
Yeah, there's a time frame, and the court allows that period of time to pass before they say you haven't had a formal settlement, you can no longer come to the court. And Often as family lawyers, if someone comes to us and they separated today, we put a note in our diary for when the expiration of their relevant time period is, and it's different if you're married or just de facto. And if we get to that 2-year mark and no settlement has occurred, we haven't done any paperwork, but we want to, then we may commence court proceedings just before the time limit's up, essentially to keep a foot in the door, so that if the other person doesn't come to the table, we've still got the ability to ask the court to make a property settlement. We haven't run out of time, so to speak.
How long is it for a marriage, that time period?
It's 12 months post-divorce. So it's much easier in a marriage, because I usually say to people, don't do all your divorce paperwork until we're wrapping up property settlement and parenting as well. So we do it all at one time.
Okay.
Because it gets a bit complicated, but you need to have been separated 12 months to divorce.
Yeah.
And then once you're divorced, you've got 12 more months before the court will say you're out of time.
Wow. Okay, noted. Wow, this is so fascinating. Okay.
Yeah. Whereas if you're de facto, the time limit just starts. You don't need to do any divorce paperwork.
So it's 2 years either way, but one of them takes into consideration separation and divorce, and the other one is just 2 years.
Yeah, two years from the date of separation.
Got it.
And people often argue about, when did we separate? What does separation look like? And it's usually when one party clearly communicates to the other. So again, I say to people, look, make sure it was really clear that you separated. So if there's any dispute, you can pull out a text message or an email or some kind of written confirmation. This is a dispute often in de facto relationships. Patrick might say we separated on this date, but the female or the male says we actually separated 2 years earlier, and sorry, Patrick, you're out of time. And Patrick goes, no, we only separated 1 year ago. I can still go to the court. So that can become a really important point between two people as well.
But then you've got a lot of off again, on again relationships.
Exactly.
You do.
Easily say, I sent you a text telling you that we're over. And then it's like,
but then we're looking at, well, did they move out? And this is why you can see there's no black and white or clear answers in family law. It's a lot of different factors, because we're dealing with real life here.
This is why the only people who are laughing all the way to the bank are you, my friend Tessa, you and your posse. All these complications.
Can get complicated. And that's exactly why I try to cut through and say, look, let's look at the emotions. And for Patrick, we should have slowed down. We should have put the brakes on. Yeah. He was acting when he was grieving. But in the same breath, we need to look at, maybe his entitlement was 50%. And the court, to an extent, takes in a property might increase in value, but that's crystal ball gazing. And the court looks at the value of the property as the date of the settlement. So Patrick's 50% of an apartment that they bought together contributed the same amount to all those other factors, might have been equal. That may well be the outcome he gets, even if he opens the can of worms again. So it's important to get some legal advice and understand, because people are always saying, I predict this property to go up and not that property. And this property has capital gains attached and I might sell that in future, but I'm not sure, but I'd like my capital gains taken into account. The court says we can't figure all of that out right now. We need to look today at what these properties are worth and what tax are they impregnated with as at the date of a settlement, not the future. So it can get pretty tricky, particularly when you've got big property portfolios with different tax ramifications, properties sitting in trust structures, et cetera, et cetera. So there's lots to unpick sometimes.
So are companies and trusts also added to the pool? Because you hear that, companies are protected and they're safe.
Yeah, no, they're in the asset pool. And that's whenever I do these talks to accountants, they always ask that. What about if we put it in a trust or a company? It's all in the asset pool. Obviously, we look at ownership, and if there's other people that have a share in the company or the trust, then that's taken into account as well. But anything you might own in a trust structure or in a company still goes into the asset pool.
Hey, it's Beck. We're doing something a little different this episode, and it's a first for us here on Investors in the Wild. We're going rapid fire, short questions, snappy answers, a minute or two or less. We're really excited to try this, and let us know if you also have questions that you would have loved to ask Tessa in the rapid fire round, and we'll ask her next time she joins us. Let's get into it. Things to consider when investing with a friend.
Not so much in my domain because it's not family law, but I can say more generally, when investing with a friend, think about how you own the property. and this is coming a little more generally from me, not so much as family law advice, but you're probably not going to be joint tenants. Tenants in common, what portion of the property you're putting on each of your names, any loan documents, if anyone's loaning money, make sure it's clearly documented. Just keep all your wishes in writing and make sure it's all really clear.
So in a breakup, if you say you own a house together, is it better to smarter to stay in the property after the breakup or to leave the property? Because oftentimes in a breakup, you don't want to stay in the same space. So does it put you at a disadvantage to leave that property?
That's a really good question. Now, from a strategic perspective, if there's no issues such as family violence, anyone's at risk, children at risk, emotional mental health is at risk, then it often helps to stay in the property because you've got a little bit of a negotiating advantage. You're in the asset and you have to force the other person's hand. If you want me to move out of this property, we need to sell it and you need to come to the table and reach an agreement. If you want me to move out of this property, we need to reach an agreement on what are we doing with our shares, what are we doing with this, that, and the other. If you move out instantly, you just essentially lose a bit of your bargaining power, so to speak, because you're out.
That's a really good point. Yeah. So
you can't get back
you're
in.
Up there. Yeah. Yeah. Okay. Beautiful.
Yeah. But that has to be overlaid by the safety components first.
Great. Okay. Makes sense.
Can prenups be broken open?
They can, but get a well-qualified lawyer so that you can be sure that they've thought of everything and given you the best protection that is available to you. And even though there's a slight weakness in the idea of a prenup, because the court can look at it, which is uncommon with a good one, that's still better than a scenario where you have no certainty at all. So that's the alternative. The alternative is you go into a relationship with no agreement on how you want to separate your assets.
If the house is in one person's name, so in your name only, and you've been together for 4 years, and then you break up, do you have the right to ask them to leave and then change the locks and just to say get out? Can you do that?
Yes.
Okay.
If the property is in your name, even if it's in joint names, you could ask the other person to leave. They don't have to if it's in joint names. But if it's in your name, you can actually change the locks. So you can force them out in that way. A locksmith will say, I will change the locks for you if it's in your sole name. But you need to also, again, that sort of position is overlaid by, is that going to unnecessarily inflame things and then make a resolution of the property settlement really difficult? So you just have to take into account the context as well. But legally speaking, yes, you can do that.
Yeah, and I was more curious about that in light of the fact that it's very interesting that other person technically can have a right to approximately 50% of the value of that property, but they don't have the right to stay in that property. That's very interesting how the rules sort of change in that regard, because you think if they've got a right to 50%, then technically you can't kick them out because they own half the property now.
It's two different elements of law in a way. It's looking at just strictly ownership. If you owned a car, you can take the car to the mechanic and you can do X, Y, and Z because it's your car. But that doesn't mean if you're in a property settlement that your car wouldn't be in the bucket of your property settlement. We're just looking at ownership. Think of it that way.
Sense. Perfect sense. Thanks, Tessa.
How do you find the right family lawyer?
I would say interview a few. Look around, ask for recommendations, have a look at the qualifications of the lawyer, make sure they practice, I would say, exclusively in family law, because that's what most of us do if we're just working in family law. And I find clients usually interview a few. Certainly I offer an initial consultation at no obligation, and then you can come in and meet face to face. And I find people are often meeting 2 to 4 lawyers face to face before they decide on the right fit.
It's like interviewing tradesmen for renovations, Daria. 3 quotes.
Everything needs an interview. Everything. It's like relationships now need an interview as well.
Totally.
And a contractual agreement.
And also talk to a lawyer early. If you're considering a separation or you're thinking we're about to buy a property, any significant financial milestone with a partner, if you want a little bit of legal advice, just talk to someone early and you can then just get an idea of what your rights are, what your entitlements are, and what sort of protection is available for you at that point in life.
Golden advice.
I feel like I could talk to you for days. I like your clients must feel the same. It's so funny because relationships are hard at the best of times. And then to think about what this would actually mean for you, Daria, what it could
Yeah.
mean for me, and to have that conversation when you're a year in, when you're 2 years in, you're
Oh
still
my
friends.
God. I'd be so offended if someone had that conversation with me. So I can't imagine having that conversation with someone. But unfortunately, we have to do it. It's so awkward.
We have to. And I say to people, talk to me about this a lot. And I usually say the best way is to blame it on someone else. So if someone's gifting you some money or there's some element of family involved, then it's really easy to say, look, sorry, my parents have said this was a condition to giving me that money, that we need to do blah. So people are starting to get a lot more confident. And I've actually seen, which I don't know is legal because I don't do wills and estates law, but some people who benefit from an inheritance, sometimes the will actually says you need to enter into a financial agreement if you're going to receive this money.
Wow.
Again, don't know if that's legal, but the understanding in some families is if you're gifted this money through an inheritance, you need to protect it properly. So it's becoming more common, but it is, an understandably difficult conversation to have.
It just sounds unromantic, but in some ways it's a practice of self-love above all other things.
Totally.
But this has been fantastic. I feel like I need to process this for a few days.
If I ever need a family lawyer, you're my woman, Tessa. I'm telling you right now. Oh my God, this has been so wonderful. We have to have you again, pretty please.
Yeah, of course. There's so many more things you probably want to know, but we can do a follow-up if there's interest in that.
Tessa is genuinely one of the most practical, no-nonsense guests we've ever had on this show, and we absolutely want to bring her back. The things I'm taking away from this episode: number one, formalize your property settlements properly, and you can save yourself stamp duty. The legal fees might actually pay for themselves. Number two, if your parents are helping you buy, documented properly is not the same as a gift, and that distinction could matter more than you'd ever expect. Number three, if you're going through a breakup and your instinct is to get it done fast, slow down and get advice first. As always, this isn't financial advice, and Tessa's general discussion today isn't legal advice for your specific situation. If any of this resonates, go and talk to a professional. It's worth it. And if you loved having Tessa on as much as we did, let us know over on Instagram at Investors in the Wild. And if you've got a burning question you want us to ask her next time, drop it in our DMs and we will make sure that there's a next time. See you next episode.